We proceed. The question for the court is, why should I follow this plea? And the rent-a-rent place has insurance. Who would have thought you could make money by renting rims to people?
Every time I have stood in front of you, I've been completely by myself. I've been dishonest. I've lied to you just to get out of here.
All right, I wish you nothing but the best. I know that being locked up, that's a lot of time. Anytime, a day at the prison, a day at the Bexar County Jail is a lot of time because you don't have your freedom. I don't think that you're a good candidate for probation. I'm going to find you guilty.
I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
Out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to
going
do
home
to
is
get
an option.
On our quandary.
What is your quandary?
Okay. The PSI indicates that there's a recommendation for DDRF, but she hasn't completed the second part of that assessment. The second recommendation would be for safety. The third recommendation is regular probation with outpatient treatment.
All right, the court can consider all those things.
I understand. She has talked to a gentleman from Haven for Hope, and he has qualified her for inpatient treatment there. So in talking with probation, because she has another assessment to do for DDRF, we didn't know if the court was ready to rule today.
Yes.
Okay.
All right, court is calling 2022 CR 5618, State of Texas versus Cassandra Valdez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense.
Judith Wemmert for the defendant.
All right, and are you Miss Cassandra Luisa Valdez? All right, you're here for sentencing. You entered a plea on January 24th. According to the plea bargaining agreement, punishments be assessed at 5 years in the prison. There's no application for deferred adjudication. The state is recommending community supervision, and there's restitution. Have both parties had a chance to review the PSI report?
Yes, ma'am, we have.
Yes, Your Honor.
Any objections to the PSI report from the state of the defense?
No, Your Honor, not to the state.
The defense has objection to the restitution, and we'd like a hearing on the restitution issues. They're a little sketchy.
All right. So before we proceed, the question for the court is, why should I follow this plea? So before we get to restitution, why should I follow a plea bargain agreement when she has several unauthorized use of vehicles? And then a new one, I guess, that was just indicted. And I have destruction of property. And she's pled to the possession of a controlled substance, penalty group 1 gram to 4 grams. And there are several cases that are being taken in consideration. So the question for the court is, why should I follow this plea?
I can't speak for the state. This was their offer, and we of course accepted it because it is a very good offer. Excuse me. As the court probably noted in the narrative of the PSI, Ms. Valdez has had less than a blissful childhood. And yes, she is a grown adult, but we all know that what happens in our childhood often carries over to our mental and other well-being as adults. She's already lost custody of her 5 children. She has no family support whatsoever. She obviously struggles with mental health, being diagnosed when she was a teenager with bipolar, PTSD, and anxiety and various other things. And as the court is well aware, the way that a lot of people who don't have a good support system deal with mental illness is alcohol and other substance abuse, which leads to criminal activity, that vicious cycle.
But at what point, and maybe you can answer this, Ms. Valdez, at what point it's no longer your childhood's fault, it's you making bad choices? What is the cutoff time? When we're 50, when we're 30? Because people come before me and they have mental health issues, they have drug issues. I can understand that. But what I have here is somebody who's using other people's cars. And this person is saying, and I know you, counsel, you're talking about the restitution,
Yes, ma'am.
but the fact that this vehicle has rims, tires, and built-in radio and navigation system that they're saying that was destroyed. I don't consider myself an expert, but I have brothers, and I will tell you, this $4,700 for rims, tires, and the built-in radio navigation system, that must have been an inexpensive rims, tires, built-in radio navigation system. Because I will tell you that I always do whatever comes off from the manufacturer. I don't add any extra. It is what it is. And my tires are very expensive, and they don't even have the bells and whistles that it sounds as this person has. So at what point is it not mental health? Because there are people who have mental health issues. They don't go around taking somebody's car, destroying it. Sure, let me have you raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Lower your hand, state your name for the record.
Cassandra Valdez.
Yes.
Okay, if you look at my criminal record, I lost my kids 4 years ago when I picked up my first son. The reason why I lost them is I got ran over by their dad, and I was in a wheelchair, and the state decided I was mentally unfit. So being a parent from 17 years old all the way to 31, 32, when I lost him, I didn't know what to do. I got into the wrong crowd. I thought people were my friends. I listened to them.
Okay, let me just tell you, if the other people were standing before me and they say they got into the wrong crowd and I asked them who's a part of the wrong crowd, they would say, you. And I know
And
if Child Protective Services took your children, I know they didn't just wash their hands of you. I know, and Ms. Wimmer probably knows too, that they give you an attorney over there and they have conditions for you to follow through. And if you have mental health issues, they get somebody to help you with your mental health. If you have parenting deficiencies, they help you with that.
Yes, ma'am.
Basically, Child Protective Services, when they take your children into care, if they don't have them placed with you, basically you have a free babysitter for an entire year to get your life together.
Yes, ma'am.
So the fact that they took 5 children from you, it wasn't just because you're in a wheelchair, because there are people who are in wheelchairs who have their children. It's because you didn't do what you were supposed to do.
Yes, ma'am. And now, I mean, I've realized that, and now I am in contact with them, and I do have an opportunity to be there for them and change my life.
Where are your
and,
children placed?
with their aunt.
Yeah, maybe you shouldn't have contact yet. And if I follow this agreement, I'm not going to let you have contact with them yet.
Okay.
All right, you can go for it.
And I mean, I really hope, I mean, I know you're looking at that paper and I've done a lot of stupid things, but I've learned from it, and I mean, I just want a chance to do better. I haven't had a chance, and I don't, they're not for me.
Oh, it's not for anybody. I can guarantee you. People who are over in the box right now, who are in custody, all of them are saying this
Yeah.
is not for me.
But I need help. I do need help, and I want the help. I do.
State, any questions?
No, Your Honor.
Defense?
No, ma'am.
All right, probation, what's the wait time for DDRL?
Your Honor, right now, the wait time will be
2 years?
about 10 weeks. It's 4 to 8 weeks for the actual wait time and anywhere from 2 to 4 weeks for medical clearance. So
We're looking at 48 weeks.
I would say 8 to 10 weeks.
Oh, you're saying 4 to 8 weeks. I thought you were saying 48
No,
weeks.
4 to 8.
All right, because I was doing the math in my head. I'm just like, We're getting into federal time. All right, is there anything else?
No, ma'am.
All right, if you were released, where would you be staying?
I got into the inpatient at Oakland's Hope. So they're just, I have a bed waiting for me. And they actually gave me a choice between inpatient and outpatient, and I picked the inpatient.
All right, and do you want to have a restitution hearing?
Yes, ma'am. I really would. I've had some interesting experiences, and I know the court has too, along the way, with people claiming things that, for example, the rims and the tires and everything. If insurance paid, then he was compensated for the value of those items.
All right, and I will tell you what he's saying in the PSI is they were not a part of that, and usually the $4,500 rims that you put on your vehicle, usually the insurance is like, no, unless you let them know, hey, I have $4,500 worth of rims, which nobody ever does. And I can't believe, they actually have a business, Rent a Rim, so you can change out your rims every week. And those rims, people who rent them pay $200 a week for them.
I don't know anybody like that.
Yeah,
I've heard of defendants that did that.
yeah, yeah. And the Rent a Rim place has insurance. Who would have thought you could make money by renting rims to people? All right. Court will sentence you to 5 years in prison, suspended and probated for 8 years. There's $1,000 fine that will be probated.
I have a question, Your Honor.
Yes.
The court said no unsupervised contact with any minor. I was just thinking about her employment. I guess if she was employed, she wouldn't be unsupervised if minors were customers or something.
Yes. All right, and Ms. Ferguson, I'm gonna want a 30-day reset on this case. You can do it as a phantom setting so that we can see if she's been transferred to DDRF. And if she hasn't been transferred to DDRF, I'm gonna want her brought back to court and we'll have the restitution hearing. State, is that enough time for you all to contact them?
Sure it is, Gary.
Okay. All right, we can go off the record. So I don't have zero tolerance in this court. You're on probation, you got to follow the rules. If there's an issue or something you feel you need help with that's not being addressed, the court is always here and you can stop in.
And how long will I have to go to DDRF?
It is, how long is the program probation? All right. All right, the court is calling 2020-22 CR 5618 State versus Cassandra Luisa Valdez. Could I have parties announced?
And Richard Garcia for the defense.
And are you Cassandra Valdez?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Cassandra Luisa Valdez who was placed on community supervision in 2022 CR 5618
Yes,
for
ma'am.
the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on March 7th, 2023 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2, on or about the 27th day of December 2023 in Bexar County, Texas. The defendant, Cassandra Luisa Valdez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
Guilty.
No, true or not true?
True.
Violated condition number 2, on or about the 24th day of January 2024 in Bexar County, Texas. The defendant, Cassandra Luisa Valdez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true? I'm sorry.
Not true.
Violated condition number 4 in Bexar County, Texas. The defendant, Cassandra Luisa Valdez, did then and there fail to report to the supervision officer as directed for the months of February and March 2024 in violation of condition number 4.
How do you plead to that?
True.
State will waive the remaining.
Did you understand by pleading true to 2 and 4, the court could find it true, grant the motion, find, revoke and sentence you up to 5 years in the prison?
Yes.
Knowing that, do you still wish to plead true to 2 and 4?
I'm being honest, yes, ma'am.
All right, the court will find 2 and
Amen.
4 true,
Yes.
and that there's no agreement, is that correct?
Judge, there is no agreement, but state would be recommending you grant state's motion to revoke and sentence to 5 years in prison.
Can I speak though?
Oh, just 1 second.
Okay.
Defense?
Your Honor, first of all, I apologize, I couldn't be here this morning. Cassandra's mother and daughter were here this morning and they wanted to testify, but they couldn't stay. They live out of town, and so they had to get back. And additionally, they were telling me that Cassandra has changed her whole life this last year. She's got a good job, and they were going to come ask for some leniency. In addition, Cassandra's asked me if she can address the court.
All right, do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Cassandra Luisa Valdez.
All right. Is there anything you would like to say?
Yes, ma'am.
Yes.
Every time I have stood in front of you, sorry. Every time I have stood in front of you, I've been completely by myself. I've been dishonest. I've lied to you just to get out of here. These last 2 years, I have completely changed my life due to the fact that my mom and my daughter have been back in my life. I didn't have them for the last 7 years because I was on meth. I was shooting up meth every single day. I would steal from them the first chance I got. My family completely turned their backs on me because I stole from them. These last 2 years, she just turned 21. She called me mom for the first time in 7 years. She used to call me by my first name. She has been back in my life. I've completely got off drugs. I am a manager at a car wash that I'm actually in the process of helping purchase, which is Cosmic. And he wrote a statement for me too, my manager. It's off of Fredericksburg and Hebner.
Have that statement.
Okay, I know. My mom was here. She was waiting. My mom hadn't been in my life in 7 years. She's completely back in my life now. And I feel like I have more to lose now. But back then I didn't even care.
All right, so here's the thing. What you're telling me, I have no corroborating evidence of that. I only have you saying it.
Okay, I can get all of that. I don't know. I didn't even know I had court, honestly. I wasn't prepared. I got told, I think yesterday.
Let me ask you this. Did you complete parenting classes?
I did. Yes, I did. I completed. Yes.
All right, probation, what has she done? Did she complete parenting classes?
Judge, don't have any indication that the parents' classes were complete. The only thing that I see completed is DDR.
She did 134 days in the BTRF.
Okay.
And that had parenting classes.
So here's the thing.
Yes, ma'am.
You've been on probation, and I'll allow anyone to ask questions.
Sorry, Judge, I forgot to mention that she did turn herself in.
Yeah.
All right, so any questions?
I was tired of running. I turned myself.
All right, so what I have before me is you've been on probation since March 7, 2023, and you really haven't done anything.
Yeah.
That's a problem. So I'm not going to continue you. So the court is finding 2 and 4 true. The court is going to revoke. The court, let me see. Was there any restitution in this case?
And
Restitution to SAPP of $57, Judge.
Has that been paid?
No, Judge.
There's to be restitution to SAPD for drug testing. That's $57.
Okay.
There should be no residing with minors and no unsupervised contact with minors. Court will give you credit for any time served and credit for any time served for any successful inpatient treatment. Court will recommend the therapeutic community, and the court will sentence you to 5 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you, okay?
Yeah, thank you for your
Thank
time.
you.
Did you understand you're charged with the offense of felon in possession of a firearm as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? You need to speak up for the court reporter. The case that he was pulled over for, where they said he had a warrant?
Yes.
What is happening with that case?
It got rejected or dismissed.
All right. So if you want, his reset date for PSI will be October 10th. Otherwise, if you want, I can accept from the state what his criminal history is, and then we can reset it for a sooner date, and you bring in whatever witnesses you would like to me to hear from.
October 10th would be fine with us, Your Honor.
Okay. So we're gonna come back on October 10th for sentencing. Does your client need a TAP evaluation?
I don't think so, Your Honor.
All right. Probation, that will be a PSI. Could I see a reset form, please? All right, once you sign the reset form, make sure you turn it back into the clerks. We will come back then on October 10th. I will make my decision based upon whatever evidence is presented to me. Do you have any questions?
No, Your Honor.
All right, thank you. Once you sign that, you're excused.
Thank you, Judge.
And are you Mr. Carmona? All right, you entered a plea of guilty on August 19th. The court found there was sufficient evidence to find you guilty. You applied for deferred adjudication and community supervision. According to your plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. There's a $1,000 fine. The state is silent on your application, and this is to run concurrent with 732605. Just one moment. There it is. All right, counsel, have you had a chance to review the PSI report?
We have, Your Honor.
Any objection?
No, Your Honor.
State, did you have a chance to review the PSI report?
Yes.
Any objection? All right, the state is silent. Defense, do you have any witnesses?
We do have a witness, Your Honor, and then, of course, would like to call Mr. Carmona briefly, but first would like Gracie Castanuela.
All right, Ms. Costanuela, lower your hand. Make sure you keep your voice up so that the court reporter can hear. What I've discovered when attorneys are before me and they start asking questions, usually the witness will turn here and turn their back to the court reporter, and it makes it difficult for the court reporter. So remember not to do that. And if you'll state your name for the record.
Gracie Castanuela.
All right, can you spell that, please?
Gracie. Gracie Castanuela, Castanuela.
All right, defense.
Thank you. Ms. Castanuela, how old are you now? How old are you? And can you tell me your
All right,
relation?
let's do this because you all have already started turning your back. Just ease over that way. I can hear you because this is my good ear, and just turn towards the court reporter.
Thank you, Your Honor. Could you briefly tell us your relationship with Jose Armando Carmona? And you said your
I'm
sister.
sorry, what did you say?
The sister.
If you could
Okay.
speak up just a little bit.
You move up closer, ma'am, make to the microphone. The front.
And just fix that. And in relation to your family circumstances, have you had and do you have regular contact with your brother? It's Jose Armando, but he goes by Armando, is that right? And can you briefly describe for us his circumstances involving his children, how many children he has and their circumstances?
He has 2 children. I believe that they're 13 10 and 12.
So it's three minor children.
Yes.
Now he has one older daughter by a
Yeah.
prior marriage, correct?
Yeah.
And all of his, has he been active and supportive in the lives of his children?
Yes. Very.
In fact, he has done his best to try to guide them and steer them and to really help them learn from his mistakes.
Yes.
His oldest daughter, Brianna, is been accepted to nursing school at UT Health Science Center.
Yes. I believe she graduates this coming year.
So she's got one more year left in nursing school.
Yes.
His other three minor children. Well, first, the mother of those children, she is deceased, is that right?
Yes.
Do you know what type of illness or disease that caused her passing?
I'm not sure what it's called, but it's a hereditary blood disease.
So she was very young, but you know, I'd like to call Mr. Carmona.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Jose Armando Carmona.
All right, defense.
Yes, okay. Mr. Carmona, as you've heard with your sister, your court reporter needs to. Okay. So, but without showing disrespect to the court, if you could make sure that your voice is directed in this direction. I know you speak somewhat soft. Yes, sir. I'd like to ask you first, Carmona, about your pre-trial supervision on this matter. Today is October 10th of 24. Is that correct? Yes, sir. As part of your pretrial supervision, when you were released on bond, did they install or instruct you as condition bond that you would have a monitor, electronic monitor? Yes, sir. Do you know what day that was installed? October 10th, 2023. So today is the 1-year anniversary of having the monitor, is that right? Yes, sir. And in the last year that you've been on bond and on monitor, has there been even one violation of any of your pretrial conditions? No, sir. Okay. And we've had to come to the court many times to get permission for you to attend functions for your children, whether it was admission ceremony to college or choir concerts or sporting events. We've done all that, correct? Yes, sir. And so to the best of your ability, given the restrictions of your monitor, have you been active in the lives of your children? Yes, sir. And you have how many children? 4 total, 3 minors. Three minors. And in terms of the 3 minors, are you providing support for them? Yes. Financial support? Yes. Where are you working? I'm working at Pioneer Flour Mills. And you've been there for what, 3 months? 3 months now. And prior to that, have you always maintained full employment? Yes, sir. And prior to that, was Zachary Construction? Yes, sir. And of course, when you had to go to different job sites, there was issues with the monitor and approval, correct? Yes, sir. At times it was. So the current job with Pioneer, you are allowed to stay in one spot. Yes, sir. So it's worked out well. Yes. And have you been notified that if you were provided some means by which you could remain out of custody, that not only is your job secure, but that you were in line for a promotion? Yes, sir. And what did they tell you would be making? $21.50 an hour. Okay. And where does that money go? To my family, my children, some to myself, of course, but mainly to my children. Other than your immediate essential needs, or just the essentials of life, do you basically provide the entirety of the support for your children? Yes, sir. Okay. And they're not going to just disintegrate in your absence, but it's certainly going to be a hardship on not just your family, but primarily your children. Yes. If you're not working. Yes, sir. Let me ask you about your circumstances in that regard. Your wife, the mother of the children, Stephanie Carmona, was diagnosed with a serious blood illness. HHT. Okay. And she passed away. Yes, sir. And do you know whether any of your children have been diagnosed with that disease? All 3 of them have it. So they're doing well physically now, but there's medical issues that have to be dealt with as well. Yes. Well, my 12-year-old is. And in fact, has Your daughter already had surgery or more? One or
Three.
more surgeries? 3 surgeries?
Yes.
Okay. And, so they are the focus of your life, is that right?
Yes, sir.
Okay. In addition to your children, have you and would you continue to provide care for your elderly mother?
Yes. Yes, sir.
And in fact, you lived with her until she went into the rehab.
Yes, sir.
If she gets out of rehab, she would be living with you.
Yes.
Is that right? And you'd be basically responsible for her day-to-day care.
Yes, sir.
Your work schedule is such that you put in a full day, but the shifts kind of vary, so you would have time to do that.
Yes, sir.
And your children that you have basically tried to raise as best you can, they're all doing well, is that right?
Yes, sir.
They're all productive.
Yes,
Positive.
sir. All of them. Yes, sir.
None of them have criminal records.
No.
You tried to teach them from your mistakes.
Yes, sir.
And have you encouraged them into extracurricular activities?
Yes, my 2 middle ones there, but they're middle school.
Is your daughter in choir,
Yes, and volleyball also.
volleyball, and your son's in basketball, football?
Right now he's in football.
And not only do you encourage them in a positive direction, you support them in terms of attending events and providing assistance in terms of the financial needs to participate in those activities.
Yes, sir.
No question, you've made a lot of mistakes in your life.
Yes, sir.
Is there any question in your mind that if given the opportunity, you could adhere to any terms and conditions that this court might set for supervision?
That's not clear.
And for the last year plus, there's not been one dirty UA, correct?
No violation.
And they've tested you at work as well.
Yes, sir.
And so you are completely sober and drug free.
Yes, sir.
And no question in your mind, you can remain that way.
Yes, sir.
And even the strictest of conditions, you will abide by.
Yes, sir.
I'll pass it.
Any questions? All right, I have a few. So the marijuana that was in your car, you said that you had loaned your vehicle to someone else?
Yes, ma'am.
Who was that?
A friend of mine, and David,
David what?
and Tele.
All right, and then this person you bought the weapon from, who was that?
I don't know personally, but a friend.
Well, no, it says here you bought the gun from a man that said he was associated with the military. So who is this friend who gave you information for this person?
I used to work with him downtown. That's what I got introduced to this man by him.
So who is he?
The
What's
man
his
that
name?
left him,
No, the friend.
You know what I talk with? No, Ryan.
Hmm?
The name of Ryan.
Ryan what?
I'm not sure I know his last name.
But this is your friend.
Well, not, it was just an acquaintance from work. I used to work at the Riverwalk downtown.
So let me just tell you what my problem is with your application.
Yes, ma'am.
You're habitual, that was waived. One of your cases that was waived, and it's in the PSI, is assault family with previous conviction. Who is the complainant in that case?
I'm not sure what case this is.
No.
Oh, it's my wife, my deceased wife.
All right. And then you have an assault bodily injury from 1997. And then you had an assault bodily injury from 1999. And then you have an assault bodily injury married from 2013. And I'm assuming that's the wife who's deceased.
Yes.
Then you had a possession case that was reduced and you were placed on probation and it was revoked because you didn't successfully complete it. Then, and that was in 2006. Then 2013, you had another possession case. You were given deferred adjudication for. You didn't successfully complete it. You were revoked. And then you had an assault family second offense. And I'm assuming that's against your deceased wife as well? And you were given probation for that and you were revoked and you didn't successfully complete it. And the ag assault with a deadly weapon, that was dismissed for missing witness. I'm not even going to consider that. And then now we have the felon in possession of a weapon. And what you state in your version of events, and if they put it down incorrectly, let me know. You state, the defendant states he was aware he was not to have a gun, but wanted one as his son-in-law had bought one. Is that the case?
Yes, sir.
All right. Is there anything else?
Maybe just a brief argument about this.
Yes.
Judge, as you pointed out, very thoroughly, you've got every reason in the world to deny his accusation. His record speaks for itself, and it is what it is. But despite the fact, oh, I'm sorry. There's no question about that. But as you've also noted, most of those circumstances are somewhat, some of them are way in the past. Some of them are remotely, are somewhat remotely in the past. But what I think, and there's no question that 15 years ago or so, he had a serious drug problem that caused a lot of issues in his life. He has addressed that in meaningful ways. He did go to treatment. And over time, I think it took effect, and he has been clean and sober now for a number of years. I think that addresses many of the historical issues that present themselves in his case. The fact that he has been on such strict bond conditions for a calendar year, a full calendar year, and it started off with complete lockdown. We were able to finally get that transitioned to partial so that he could resume work. And he, in essence, has proven himself. I think that a year of what he has been through without a single violation, I am hard pressed to think of a man in his circumstances that has performed as well on pretrial supervision as he has. So, and it hasn't been for just a week or a month. It's been for a full calendar year. So I think the track record he has established since his arrest on this case has established that he's capable and willing to not just comply, but satisfy each and every term of condition the court might impose, no matter how strict. The question is, does his record allow him the opportunity to do that? That's what we're imploring the court to kind of look at the big picture. And when you factor in the circumstances, the family circumstances that are created, and with his absence, the hardship that it creates on the children, and the fact that he has proven himself so much for the last year, we're just imploring that the court consider some form or fashion of conditions and combination of conditions that would satisfy all concerned. Certainly, on paper, he doesn't deserve another chance. Given his performance over the last year and how he's proven himself, we're imploring the court to consider some combination of conditions, as strict as they might be, that would allow him the opportunity to continue to prove himself.
All right, thank you. All right. I want you to know that I would listen to your attorney's argument. I've listened to the witnesses that have been called, and I always internalize everything that's told to me. And I always reread the stipulations and make sure that I read the TAP evaluation. Here's the court's issue. The issue is that according to your versions of event, you knew you're not supposed to have a weapon. It's the law. You're not supposed to have a weapon. If people don't like that as a law, they need to change it. And according to your version of events, you wanted a weapon because your son-in-law had one. And then you went through back channels because you knew, according to your versions of events, that no one would sell you one. And it's not as though you're a teenager and you're not considering or internalizing the consequences of your action. That's a problem for the court. I don't think that you're a good candidate for probation. I'm going to find you guilty. This we're going to write concurrent with 732-605. I'll give you credit for any time served. There's $1,000 fine. Time and money will run concurrent. I do acknowledge the fact that you've done great on GPS and you've done everything well. Your punishment is set at a cap of 8 years. And based upon how you've been since you've been on GPS, I'm going to sentence him to the 3 years.
Thank
Right.
you.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. With your history, I know sometimes people will say, oh, it's better to ask for forgiveness than to ask for permission. With your history, you're going to have to ask for permission every time. And you know you're not allowed to have weapons, so you can't have weapon. And then, as you know, when they arrested you, they saw that you had a warrant, and that was for another incident that was dismissed because of a missing witness. And your attorney will talk to you about that, about statute of limitations and all that entails. All right. I wish you nothing but the best. I know that being locked up, that's a lot of time. Anytime, a day at the prison, a day at the Bexar County Jail is a lot of time because you don't have your freedom. But at the end of the day, you can still get out and do better. And your children will be still waiting for you. You understand?
Yeah.
All right. Good luck to you. And thank you. I remember you. I know you always dressed appropriately for court, and I want you to know I really appreciate it.
Thank you.
All right. Thank you.
Summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor. So I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a
Okay.
discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
sorry.
Um,
I'm here because I'm told to be here today, Your Honor. That's the only.
I know.
So what I want to
It kind
do.
of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in
Yes.
this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you, if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you
later
request
challenge.
an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until full
Suppression of what evidence?
of body cams, squad footage,
On what basis would you be doing that?
Miranda versus Arizona,
Which says what?
that I was not read my rights prior to being detained. And because of that, any violations that I could have possibly said that could impede my case.
That's your basis for the suppression of body cam?
That I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it, anything that happened. I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda?
As you're calling it, your motion's denied.
Okay. Maybe I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there's full discovery in this process.
Okay. Have you sent a request to the prosecutor's office for discovery?
I have not. No.
Have you asked them, how do I get discovery?
No, I will be doing that.
Do you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay. Well, I'm going to, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best. You may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand. And that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir? Your Honor?
The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. All right.
What do I want to do?
Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do
Yeah,
and maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process, because
Appreciate
otherwise this thing could could much go south for you.
Yeah, I
And
understand.
not be good, but I'll let you think about that. That's your call.
All right.
Court's in recess.
All right.
Court recalls case People versus Daniel McGraw.
In your honor,
State your name.
Daniel Magoo.
All right.
Your Honor, when the court passed this case, and left the bench, the defendant did hand me a copy of his motion. I took the recess of the court to file a response. I hand delivered it to the defendant, as well as handing the copy to the court. If I may just respond to the record.
Yes.
Thank you. So, this motion was sort of put in 3 different sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that. As the court is well aware, depositions are not appropriate in criminal court. Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay.
All right. You got any response to the people's response?
Not for that, Your Honor.
No. Motion denied.
Thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Well, here's what I'm going to do, at least at this point, is I'm going to deny the motion, that portion of the motion also. When he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely. Thank you so much. Number 3 was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I responded that request was unclear, but it appears to be that the people execute a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in the police report currently in possession of the people. Unless otherwise directed by the court, the people would think that people do not intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I can show you it. It's quickly available here for me to show you, but he's really within.
I really would be
grasp.
That the defendant showing anything to the court that he has not disclosed to the people.
So, given that I do have FOIA on my CAD records for the dispatch record of the police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants. I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is Jacob Spalding. I've known him for 15 years. I was with him throughout the course of the night and was.
So you want his medical records?
I want to, first of all, subpoena him to get his witness, statement on record officially. And I would also like his records due to the nature of why they.
I'm not going to order. I'm not going to order medical records. If you tailor a request for something that isn't available in another fashion, then that's fine, but I'm going to deny that motion.
Yeah, a lot of my civil procedures, I will be correcting and will not have any more problems with. But as for right now,
Your civil procedures?
I'm trying to follow the rules of federal civil procedures, and this is my
Of federal?
Yeah, this is.
Yeah.
I think so.
Okay, so we're a state court.
Okay.
And this
I'll
is
try to
criminal
follow state
proceedings.
ways then. Thank you for your guidance.
Yeah, so you might want to start there.
Okay.
Okay,
So that 3 is denied.
huh?
3 is denied, Your Honor.
The whole motion's denied, yes,
Thank you.
all three parts.
Number 4 was to subpoena a witness. I just responded that the defendant should follow the subpoena process available to him.
That's it.
Understood.
Okay. Number 5 was that the defendant is requesting the report produce all audio or video recordings. I said he should go through the discovery process. That's that motion at this point. Like, don't.
It's denied.
Thank you.
You can
Number
get
6,
to him.
the people, I'm not exactly sure. There's a motion to seal statements.
I don't know what that meant.
I don't either.
What does that mean?
It means any statements that I made under stress to either the police officers when they were questioning me or before, after.
What do you want to do with them?
I would like to suppress them so that they don't hinder my trial experience, as I was not.
What does that mean?
Well, I was not given proper notice of my rights when I was detained, and I was questioned thoroughly afterwards.
You have to file a motion. You'd have to lay out specifics as to how and or another any statement that you made, which it doesn't sound to me like was the subject matter of necessarily an custodial interrogation, but it doesn't really matter. You're going to need to lay out all the elements of that before I would rule on that. But in its form, as it sits right now, that motion's denied without prejudice.
Thank you. My response to number 7, which is the defendant is notifying the court of exculpatory video evidence. Okay. I don't have any response to that, really, beyond the fact that it seems that these are videos the defendant has, and that he hasn't received any videos from my office yet, so I don't see how
I have
to
video.
respond to any piece of this.
I have videos, both FOIA requested from the Ypsilanti Police Department and my own. I was formalizing the process for the prosecutor to build her prosecution.
To do what?
When I requested discovery items that I'm going to do following the rules of civil procedure. That's what I was, yeah.
So this last one, what are you going to do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't, you seem to want this process to work away. It doesn't.
Maybe that's the disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied.
Number 8, defendant requests the court cancel all current bond conditions pending the.
Motion denied.
Thank you. Motion to continue proceedings. People weren't opposed to adjournments, but this is actually kind of includes several things. The request is to continue all scheduled hearings until requested testimony, evidence, and hospital records are provided. So I don't have an issue if the defendant needs more time to be prepared to have hearing, but I do have an issue if he's trying to say that he can't do anything until we subpoena somebody's medical records. So I'm going to get a search warrant for somebody's medical records and to depose officers in a criminal case.
Which both of those have been denied. So by default, that would have to be denied if that's what he's asking.
I've made a note of the new address mentioned in section 10, and then there's number 11 is to seal all indictments. I don't know what this means.
I don't know.
All incident related documents and evidence. I don't know what that means.
What does that mean?
It's reiterating the sealing. Anything that I said is really all.
I don't know how that sealing would take place.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied.
That's all. Thank you, Aaron.
Okay, so what are we gonna do?
Well, I would like a chance to amend the motion.
No, you can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
So what do you wish to do now? Do you wish to have a preliminary exam set?
Yeah, I'd ask for some for adjournment in order to review the discovery materials I've produced from my FOIA.
That what?
That I've came up with through my FOIA request. Or I'm going to plan on submitting the procedures as normal through the prosecution too, as well. But I need time to review the
What does
documents.
that mean?
That means I just got the documents and I haven't been able to review them, and I need time to review them. Your Honor. I can't decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment?
After this response that I submitted to her and she submitted back, yes, sir, Your Honor. Adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because.
Thank you, Your Honor.
And Your Honor, for the record, I put the email address the defendant should contact for discovery on this Post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about this case.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case. So I've given him the Post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right. Probable cause conference. Let me at least have some turkey before I have to deal with this again. December 5th. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood so that we don't get into, you need to remove the gum from your mouth. And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a
You wish to have a preliminary examination?
preliminary examination? Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the board be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping to sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yep.
12 noon, that is before me.
Thank you, Your Honor.